A brand spends $25,000 commissioning a full marketing campaign from a freelance creative agency. The campaign launches, it performs. A year later, the brand tries to reuse the materials and discovers it can't. Why? Because nobody got the paperwork right and the copyright still belongs to the agency. A filmmaker hires an artist to create an original piece of art for a documentary. The film gets picked up, the distribution deal's on the table, and then the filmmaker learns that the artist who was paid, who delivered the work, who moved on, still legally owns the underlying copyright. The deal is now complicated. These aren't hypotheticals. These are the kind of situations I see in practice, not all the time, but more than I should. And in every one of them, the root problem is the same, a fundamental misunderstanding of how copyright law actually works. I'm Scott Hervey, a partner with the law firm of Weintraub Tobin, and today I'm joined by my partner, Richard Buckley. We are going back to basics, copyright fundamentals, what it covers, who owns it, and what rights it creates, and what happens when those rights are infringed on. We're going to talk about that all in today's installment of The Briefing. Richard, welcome back to The Briefing.
Great to be here, Scott. Thanks for having me.
Yeah. Okay. So today we're going to do a semi-deep dive on copyright law basics. I know basics sounds like basics. It might not be the most exciting topic, but I think in my experience and misunderstanding of copyright fundamentals is at the root of a huge percentage of the issues that I see. So we're going to lay this all out properly, from what copyright protects to how ownership works to what the remedies look like when somebody infringes.
And Scott, I think that what's interesting about copyright compared to other areas of IP is that it touches virtually everyone, creators, businesses, developers, influencers. You don't have to be in the entertainment industry for this to matter.
Oh, I agree. I mean, copyright touches on real estate law, right? So, right, the entity or person commissioning any type of work that's covered by copyright, and that could be a logo or some design for a startup. It could be architectural plans for a real estate developer. In the entertainment industry, it could be the studio licensing a screenplay or commissioning a screenplay. They're all dealing with the same underlying legal framework. So let's get into it. All right, let's start with what copyright covers. So copyright law protects original works of authorship that are fixed in a tangible medium of expression. So let's break that all down. Original doesn't necessarily mean novel or unique in the patent law sense. It just means that the work originated with the author, that it wasn't copied from someone else, and that it has at least a minimal degree of creativity. The Supreme Court addressed this in Feist Publications versus Rural Telephone Service. That's the famous telephone case that we all learn in law school, or telephone book, Yellow Pages book case. The court held that facts themselves, in that case was dealing with competing Yellow Pages or phone books. And the court held that facts themselves are not copyrightable, and that the particular arrangement of those facts, in that case, a straightforward alphabetical listing of names and phone numbers, lacked the minimal creativity necessary for protection. So yes, copyright has a low threshold, but it's not zero.
The Feist case is interesting because it does set a floor, but it's a very low floor. Most creative works clear it easily.
Right. A photograph, a software program, a blog post, those all clear it without any difficulty. Where it gets litigated is at the margins, databases, directories, compilations, whether that be a compilation of data or a compilation of poems or any type of compilation. The question is always, was there any creative judgment exercised in selecting or arranging the material?
The other requirement, Scott, is fixation. And what does that mean practically?
Right. It means that the work has to exist in some concrete, stable form, written down, recorded, saved to a hard drive. Copyright doesn't protect a purely improvised, like oral performance that was never captured. The moment you write it down, record it, upload it, take a picture of it, it's affixed and copyright protection attaches automatically.
But what about something like a live stream or like a TikTok draft that's never published?
A good example. If a live stream is being recorded simultaneously as it's being transmitted, which is always the case on platforms like Twitch or YouTube Live or any type of live platform, the fixation happens. It happens in real time. The copyright attaches. If you think about it from a technological standpoint, there has to be a recording when I am taping this podcast now, and if we were live streaming it, the fixation happens somewhere along the stream from me sitting here recording it to you as the viewer watching the live stream. And when that fixation happens in real time, and copyright then will attach. A draft is saved to it. When a draft is saved to a server, even if it's saved momentarily, it's fixed. It doesn't have to be published or released to the public for copyright to exist.
So, what categories of works does the statute cover?
The Copyright Act lists 8 categories: literary works, musical works, dramatic works, pantomimes and choreographic works, pictorial, graphic and sculptural works, motion pictures and other audiovisual works, sound recordings, and architectural works. So that covers a enormous range, right? Novels, songs, movies, photographs, software code, websites, podcasts, and scripts.
Is there anything that's explicitly not covered?
Yeah, it's a good question. And it's where a lot of disputes turn. So copyright does not protect ideas. It doesn't protect procedures, processes, systems, methods of operations. It doesn't cover concepts or principles. It also doesn't cover short works. For example, sentences or a short phrase or a title. Only the expression of an idea is protectable, not the idea itself. And there has to be enough of the expression in order for it to be protectable. You can copyright your specific novel about a wizard school, but you cannot copyright the concept of a wizard school. That distinction, the idea expression dichotomy, is at the heart of a huge percentage of copyright disputes.
And that distinction matters when we get to infringement too, right? Because you can't just look at whether someone copied something. You have to ask, what did they copy?
Right, exactly. And we'll come back to that when we get to substantial similarity. But let's talk about ownership. Ownership is where I see clients get into a lot of trouble. Serious and most avoidable trouble, though. The basic rule is that ownership vests initially with the author. That's the person who actually created the work.
Which sounds straightforward until it isn't. It stops being straightforward almost immediately. The first complication is the work for hire doctrine. Under the Copyright Act, a work made for hire is either a work created by an employee within the scope of their employment, or a work specially ordered or commissioned that falls within certain statutory categories, and where the parties have expressly agreed in a signed written agreement that it's a work made for hire. If a work qualifies as a work made for hire, the employer or the commissioning party, not the creator, is considered the legal author and owns the copyright from day one.
Right. So for employees, that's relatively clean, right? If I hire a graphic designer and they're on payroll, they're an employee, the work that they do in the course and scope of their job, the copyright belongs to the company. The Supreme Court clarified the boundaries of this in a pretty famous case, Community for Creative Nonviolence versus Reed. And that case established that whether someone is called an employee for copyright purposes isn't really determined by what the contract calls them. It's determined by applying common law agency factors. Does the hiring party control how and when the work is done? Does the worker use their own tools? Is the relationship ongoing or a project by project basis? You can call someone an independent contractor in your agreement, or you can call them an employee in your agreement. But if the relationship still looks like employment under those factors, Or generally the situation is where you call them an employee, but the situation and the facts are that they really look more like an independent contractor. Uh, the work for hire issue vis-a-vis an independent contractor might still be there. And if you don't have a written agreement between the two parties, which says that the work is work made for hire, there might be a big issue.
And that's a trap right there, because a lot of businesses think the label in the contract controls when in fact it doesn't. And the flip side is also a trap. If somebody really is an independent contractor, you can't just rely on calling the work for hire in the contract. The commissioned work prong of the statute only applies to specific categories, contributions to a collective work, parts of a motion picture or audiovisual work, translations, compilations, and a handful of others. If the work doesn't fall into one of those categories, it cannot be a work made for hire as a matter of law. Full stop.
Right. And that's usually why when you have a work made for hire provision in an agreement, in the same paragraph, you also have assignment language. And it says if the work is not a work made for hire, then the vendor hereby agrees, or the employee or independent contractor, whatever you call them, hereby agrees to assign all right, title, and interest into the work to company, right? You use the belt and suspenders approach, and that usually addresses it. And I will say, this is, I hear this a lot. This is the kind of thing where a business owner says, but I paid for it, I should own it, right? That's the most common reaction, and it feels intuitive, but it's wrong. It's wrong. Payment alone doesn't transfer copyright. Only a written agreement that says it's a work made for hire, or a written assignment, or where it's an employer-employee relationship. If you don't have one of those things, written assignment, work made for hire agreement, or employee-employer situation, you might be out of luck. You might really be out of luck. You might own nothing more than a copy of the deliverables, and that's it. The independent contractor may retain the copyright unless there's a valid written assignment, a valid written work made for hire agreement, or it's really an employer-employee situation.
You see this in the creator economy constantly. YouTubers commissioning editors, influencers hiring photographers, brands paying designers for social content. You see it all the time. A brand pays a photographer for a shoot. The photos go up on Instagram. A year later, the photographer sends a cease and desist because no one signed a copyright assignment. Or a startup pays a developer to build their app. The developer walks away with the code legally. These situations are entirely preventable with the right agreement in place from the start.
Right. So let's talk about what the right agreement looks like. So at a minimum, a written agreement signed by both parties that either one expressly states that the work is being created as a work made for hire, and let's make sure that the work falls within a qualifying statutory category. And even if it does, you've got the belt and suspenders. It should also contain a written assignment and a written assignment of all right, title, and interest into the work, regardless of whether or not the work actually does qualify as a work made for hire. As I have said here now, at least probably 3 or 4 times, my recommendation is that the contract has to include both those provisions in the same paragraph. As I said, belt and suspenders. If the work made for hire clause fails for any reason, the assignment clause is going to.
One other wrinkle worth flagging, Scott, joint works. If 2 people each contribute copyrightable expression to a single work, you have a joint work, and both authors own equal undivided interests. Either co-author can license the work to a third party without the other's consent, though they owe their co-author an accounting of any proceeds. That rule can create real friction. One co-author can license the work even if the other disagrees.
Right, that's true. And the other co-author can't stop them, but the co-author that's exploiting the work does owe the other co-author accounting. Um, let's also add, like, in community property states like California, there's another kind of interesting layer, and that is the non-author spouse. They may have a community property interest in the copyright created during the marriage. It is an asset. It can create some unusual ownership questions that can come up in estate planning and in divorce proceedings.
So let's talk about what happens when copyright is infringed. The copyright owner holds a bundle of exclusive rights, the right to reproduce the work, to prepare derivative works, to distribute copies, to perform or to display the work publicly, and for sound recordings to perform the work digitally. Violating any of these exclusive rights without authorization is direct infringement.
Right. But it's not just the person doing the copying who can be liable. There's also contributory infringement. That's where you are knowingly and materially contributing to someone else's infringement. And there's also vicarious copyright infringement liability, where you have the right and ability to control the infringing activity and you receive a direct financial interest in the infringing activity. Platform liability cases often involve those theories.
So if someone copies something from my work, that's not necessarily automatically infringement. And this is a point that trips up a lot of people. To establish infringement, you need to show ownership of a valid copyright and copying of protected expression. That second part is important. Copyright only protects expression, not ideas, facts, or unprotectable elements. If somebody copies your idea, your concept, your general approach, not infringement. The copying has to involve the specific creative expression.
Right. And that's the issue. That's the question of substantial similarity. Courts use a substantial similarity analysis to assess whether the allegedly infringing work copies enough protected expression to constitute infringement. And this is where cases get complicated, because you have to filter out the unprotectable elements, the ideas, the stock scenes, the like fundamental unprotectable elements, facts, and ask whether the what's left, the protectable expression, is substantially similar enough. It's highly fact-specific inquiry, and it's like, honestly, it's why copyright litigation ends up being expensive.
Let's talk a little bit about fair use. I mean, that's the defense. Everyone thinks protects them and usually doesn't. Fair use is real, but it's also widely misunderstood. Under Section 107, certain uses, criticism, commentary, news reporting, teaching, scholarship, research, all of those may qualify as fair use. Courts weigh four factors: the purpose and character of the use, the nature of the copyrighted work, how much was taken, and the effect on the market for the original.
Right, right. And that first factor, the purpose and character of use, it's where the transformative use doctrine comes in. And that, as we know, has gotten a lot of attention lately. Courts look closely at whether the new use is transformative, meaning does it add something new? Does it alter the original with a different purpose and character? Or does it simply substitute? Is it simply a substitute for the original? A use that is genuinely transformative, it does weigh in favor of fair use, but transformative use alone isn't the magic word. You still have to weigh all of the four factors. And the fourth factor, market harm, carries significant weight if your use competes with or displaces the original in the marketplace. That cuts strongly against fair use. And in that analysis, the purpose of the new use has to justify the copying.
This comes up constantly on social media. Someone will repost a photo or a clip and say, I added commentary, it's fair use. And sometimes that's true, but sometimes it's not. Adding a 2-word caption to a repurposed photograph does not transform it. Adding substantive commentary, criticism, or analysis that gives the work a new meaning or message, that's a different conversation. The line isn't always clear, but the assumption that any comment or credit makes something fair use is wrong.
Right. Yeah, actually, there's a case that a court is considering right now. And I mean, it's funny. It's kind of gotten the name like lazy commentary, and it's about a YouTuber commenting on and criticizing a long form film. And at certain points, they do add criticism and commentary, but at other points, they like get up and leave. So, and the court has to figure out like, is this enough to constitute fair use? Because there are portions where, yes, they are they are engaging in criticism and commentary, but taken as a whole, is that going to be enough? So it's an interesting case, and once we have a an opinion from the court on this, we're going to talk about it in another one of our podcasts. All right, let's getting back to this podcast though. So let's talk about remedies, shall we? Because that's ultimately where the stakes become tangible. This is where things get real. Copyright owners can seek injunction. That's a court order stopping the infringing use. They can also seek actual damages plus the infringer's profit. But the most powerful remedy, and the one that gives copyright owners real substantial leverage, is the statutory damages and potential for attorney's fees recovery. Statutory damages are only available if the work was registered before the infringement began or within a certain period of time from first publication. The 3-month window is measured from publication, not creation.
From a business perspective, that timing distinction matters a lot. If you register on day one of publication, you're fully protected. If you wait until after infringement occurs, you're limited to actual damages and the infringer's profits, which can be very difficult to prove and very small in practice.
Right. Statutory damages, though, they range from $750 to $30,000 per work infringed at the court's discretion. And if the infringement is willful, that ceiling jumps up to $150,000 per work. And the court, as I said, can award attorney's fees to the prevailing party. That's why registration matters so much. It converts a weak damage case, like, for example, where someone just reposts your work for free on the internet. How do you measure damages where there's no income received by the infringer? So it converts that from a weak damages case into a case with real leverage.
Thinking for a moment about, registration as a prerequisite to filing a suit in the first place. For U.S. works, yes, generally registration must be completed, meaning the Copyright Office must have acted on the application before you can file an infringement lawsuit in federal court. That was clarified by the Supreme Court in Fourth Estate Public Benefit Corp versus wallstreet.com. You can register after infringement occurs and then file suit, but you've already lost the ability to elect statutory damages. So the time to register is before infringement, not after.
All right, so let's bring this home. What are the practical takeaways? So I'd say first, the registration point deserves the lead because it's one action item that can change everything downstream, and it's relatively easy to take care of.
Yeah, I agree, Scott. First, register your copyrights and register them early. If you're creating original content, software, marketing materials, creative works of any kind, register with the Copyright Office at or near the time of publication. It's inexpensive, it's straightforward, and it's the single most important thing you can do to preserve your remedies if you ever find yourself in a position of having to enforce your rights.
Right, I agree. And for the creator economy specifically, YouTubers, podcasters, photographers, designers, this is a step that most people skip because they think registration is only for big studios or major publishers. It isn't. Anyone who creates original content and wants to be able to enforce their rights needs to register.
And second, get your contractor agreements right. If you're commissioning creative work from anyone who isn't on your payroll, you need a written work for hire agreement if the work falls within a qualifying statutory category, or a written copyright assignment. Both in the same contract is better. Oral agreements are worthless for copyright ownership purposes. This applies whether you're a startup, commissioning a website, a brand, hiring a photographer, or an influencer working with a video editor.
Right. And if you're on the other side, if you're a freelancer, the developer, the photographer, understand that without a valid work for hire agreement or assignment, you may retain the copyright even after you've been paid. It's a two-sided issue here.
Third, copyright notice still matters. While it's no longer legally required, a proper copyright notice, the copyright symbol, the year, the owner's name, puts the world on constructive notice that the work is protected. It undercuts an infringer's argument that they didn't know the work was copyrighted, which matters for willfulness and for the possibility of maximum statutory damages.
And fourth, if you receive a cease and desist letter claiming copyright infringement, don't ignore it, but don't panic either. Get a lawyer involved to evaluate whether the claimed copyright is valid, whether the infringement claim can hold up under a substantial similarity analysis, or whether fair use applies, and have an idea as to what your real exposure is. These letters range from meritless to very serious, and you need to know which one you're dealing with before you respond. Well, that's going to do it for today's briefing. Richard, thanks for joining me today. Always great to have your insights. And thank you to our listeners for joining us. If you found this episode helpful, please take a moment to subscribe, like, and share it with your network. We'd love to hear from you. Leave us a comment or a review and let us know what topics you would like us to cover. I'm Scott Hervey. We'll see you next time on The Briefing.